It's amazing to be here among such amazing people, such people who integrate scholarship, practical activism, and passion, and morally driven passion. It's just amazing. But I also want to, before I begin, to thank the grassroots activists in North Carolina who've been at this for well over a decade, who've made this happen. They are an amazing, amazing national treasure. I've been so honored to have met them and got to know them, and I think we need to acknowledge that. If only we had groups like this in every state, maybe things would be a little bit different in this country. So we've been hearing about the horrors of torture and the moral repugnance of it. I'm going to talk about a group of people who should know this as well as anyone, but seemed in many cases not to, which are health professionals. I'm a psychologist. What does it say? Yeah. Psychologist and psychoanalyst and researcher, for those who don't know. Bioethicist Stephen Soldz pointed out a decade ago that there were more healthcare professionals, doctors, nurses, psychologists, physician assistants, and others involved in designing, implementing, and protecting torture than in treating its victims worldwide. This testimony outlines some of the major locations and functions of these health professionals in the US case. I've submitted a more detailed written testimony that expands on what I say here and has references and raises some additional issues we won't have time for. Best known among these health professionals is the involvement, and we've heard their names several times today, of James Mitchell and Bruce Jessen, psychologists who retired from the military and went to do contract work for the CIA to design and implement the CIA's enhanced interrogation techniques, the EIT program, that we've been hearing about its effects today. While Mitchell and Jessen have received most of the attention regarding psychologists' involvement in the EIT program, and especially since the ACLU lawsuit, it's important to remember that there were many other psychologists and other health professionals involved. A number of other psychologists reportedly worked for Mitchell, Jessen and Associates, and a number of other staff there had, quote, advanced psychological degrees. Health professionals, including physicians, psychologists, and physician assistants at a minimum, from the CIA's Office of Medical Services, OMS, were involved in monitoring detainee interrogations in the EIT program. These health professionals should be seen as full collaborators in the torture. They usually pass off there. The Senate Select Committee on Intelligence Torture report indicated that some in OMS raised concerns about aspects of the torture program. Specifically, they were concerned about when OMS was going to be assigned the role of assuring that EIT interrogations were safe. OMS staff responded that making this assurance was not their role. As long as other people assured it, that was fine. However, I'm not aware of any public evidence that any OMS staff refused to participate in the program. Another revelation that hasn't gotten much attention is that from the Senate report was that in many instances, physician assistants were personnel in providing the medical monitoring of the CIA interrogations. We had not previously known this, and as far as I'm aware, physician assistant associations have not responded in any way to this. In 2010, another aspect is human subject research. In 2010, Physicians for Human Rights, PHR, issued a report, of which I was a co-author, called Experiments in Torture: Evidence of Human Subject Research and Experimentation in the Enhanced Interrogation Program. We argued that, in addition to torture, the CIA's EIT program included illegal human subject research. The report documented several instances where data were systematically collected during torture and used to modify torture protocols. This data collection and use to create generalizable knowledge met the federal government's legal definition of human subject research, we argued. And we filed complaints with the government that, of course, did not get very far. PHR issued a second report this year in June entitled Nuremberg Betrayed, Human Experimentation and the CIA Torture Program. Drawing from dozens of newly released documents from the ACLU lawsuit against Mitchell and Jessen, as well as other news sources, PHR goes beyond what we said in 2010 and argues that the EIT program in itself was a form of human subject research. This report argues that, as Sarah Doherty, lead author, put in an interview, quote, the CIA's post-9/11 torture program constituted a regime of illegal human experimentation. Based on a review of thousands of declassified documents, the report shows that health professionals who designed and implemented the torture program committed a second and related crime, experimental research to investigate the effects of torture on detainees. The CIA research explored the untested hypothesis that torture could psychologically break detainees' interrogation. Remember, after World War II, doctors were executed for the crime of illegal human subject research on prisoners. If this argument regarding the EIT program as human subject research is valid, it's important for another reason, because it opens up an avenue of potential liability for those who authorized and implemented the torture program. Because these acts, human subject research, would not be covered by the Justice Department torture memos. And therefore, whatever shield the existence of those memos would have, people arguing, well, we were only doing what the government lawyers said was legal, would not apply here. Health professionals also played central roles in the enhanced interrogation program at Guantanamo. In fall 2002, a psychologist and a psychiatrist from Guantanamo's Behavioral Science Consultation Team, BSCT, pronounced Biscuit, and the individuals are known as Behavioral Science Consultants, BSCs. They received training in interrogation, including torture, at North Carolina's Fort Bragg, another North Carolina connection. Upon their return to Guantanamo, they were tasked with writing a memo outlining harsh interrogation techniques to be used with high-value detainees at the facility. Despite reservations, these health professionals carried out this task. That memo became the basis of the request to the Secretary of Defense for authorization to use a number of enhanced techniques. Secretary Rumsfeld signed off on the use of a number of these techniques, 23 I believe, in a December 2nd, 2002 memo that, thanks to Alberto Moro and others, was rescinded in January, but many were reauthorized secretly in April of 2003. The Biscuits also consulted to abusive interrogations and suggested abusive tactics to be used to break detainees for at least a number of years at Guantanamo. Early reports out of Guantanamo, such as the 2003 Red Cross report that first called attention to the role of the Biscuits, claimed that information in detainees' medical files was being used by interrogators. For example, interrogators might use knowledge of a detainee's insect phobia. This claim has been consistently denied by government personnel who claim that medical information is only used appropriately to protect detainees' health. While it's been hard to definitively resolve this question because of the secrecy of materials, it should be noted that the Biscuit policy documents definitively contain a loophole that could be used to justify this use. Any use of medical information for national security is allowed. Health professionals have also assisted in other abuses at Guantanamo, including physicians and nurses ordering and participating in non-consensual force-feeding of competent hunger strikers in violation of American Medical Association and World Medical Association ethics guidelines. Especially problematic at Guantanamo is the mental health care system. Apparently, all such care is provided by military mental health professionals, including psychologists, psychiatrists, nurses, social workers, and behavioral health or psych technicians. Mental health services are especially important because Guantanamo detainees constitute a severely traumatized population. Many were abused or tortured either prior to rendition to Guantanamo or at the facility. Further, the situation of indefinite detention without trial, true for the vast majority of those who were imprisoned at the facility, is one designed to arouse intense anxiety, despondency, and hopelessness, all which increase the likelihood of negative mental health outcomes. Despite the need, however, structural factors and situational pressures make effective treatment extremely problematic. Mental health treatment even more than physical health treatment, depends on strong trust between patient and treating professional. This relationship is often called the therapeutic or working alliance. A large body of research indicates a strong relationship between the quality of that alliance and therapeutic outcomes in mental health treatment. The circumstances at Guantanamo interfere with the creation of that trust. Another major factor interfering with effective treatment is abuse of many of the detainees, either prior to arriving at Guantanamo or at the facility. There seems to be a systematic pattern of military mental health clinicians failing to inquire about abusive treatment or, at a minimum, failing to document that treatment in medical records. Those of us who've seen medical records from there are astounded that none of us have seen any documentation of any questions about potential torture or abuse, any investigation of potential PTSD, despite the existence of clear PTSD symptoms in many of the detainees. As Sherry Fink of the New York Times reported in the Times, quote, psychiatrists and psychologists said they had almost never asked a detainee about his treatment by interrogators, either at Guantanamo or at the CIA prisons. And how in the world can you conduct decent mental health treatment if you can't ask about what might be causing it? It makes no sense. Health professionals also provided legal justification for staff in the torture program. The Department of Justice's torture memos redefine torture to require severe, long-lasting harm. For many of the techniques discussed in the memos, references were made to claims by health professionals that EITs, as they were to be implemented, would not cause severe and long-lasting harm. Further, the argument was made that a good faith assurance that a technique would not cause harm could be attained by having health professionals assess detainees prior to their subjection to EITs, as if they really can determine who's going to be hurt by being tortured, and to monitor the administration of the EITs. Thus, health professionals served as a get-out-of-jail-free card for those authorizing and implementing the torture. Other health professional involvement. Bioethicist Stephen Miles documented a number of other types of involvement of health professionals in U.S. torture. And I think part of the lesson here is how torture corrupts the society and increasingly corrupts larger segments of it. Among the acts he cites are cover-up of potential homicides through inaccurate death certificates, failure to look for evidence of abuse in autopsies of deceased detainees, failure to correct false statements regarding causes of death put forward by Defense Department officials, neglect of medical problems of detainees, failure to document abusive detainees, and failure to report abusive detainees as required by the Uniform Code of Military Justice. As news of health professional involvement in U.S. torture became public starting in 2004, health professionals were implicitly faced with two distinct but related ethical issues. The first was how health professionals were to respond to activities that are in themselves unethical, such as torture or CIDT. The second issue is whether health professionals should limit involvement in otherwise ethical interrogations because of their professional standing and their professional ethics. Physician groups, including the AMA and the American Psychiatric Association, adopted policies asserting that physicians should have no direct role in the interrogation of individuals, because involvement in interrogations conflicted with their members' role as hewers. And this included domestic interrogations as well as national security interrogations. However, unfortunately, these associations took no steps to discipline members who participated in interrogations and who participated after these policies were formulated, thus jeopardizing their clear ethical stance. The American Psychological Association took a different approach. In 2005, the APA appointed a presidential task force on psychological ethics and national security called the PENS Task Force. This 10-member task force included a chair with no expertise in national security or interrogation issues, who was mentored by the APA ethics director, who was the lead person in the APA on this material, 3 uniformed military officers, and 3 others employed or consulting to the Department of Defense. So a majority connected to the Defense Department. Several of these individuals had personal involvement in national security interrogations. The PENS report asserted that psychologists are in a unique position to assist in ensuring that these processes are safe and ethical for all participants. It stated that psychologists should not participate in torture or cruel, inhuman, or degrading treatment, CIDT, but base its statements on U.S. law, not international law, leaving psychologists free to participate in interrogation activity deemed legal by the U.S. government, as both CIA and DOT torture were. The task force echoed then extant APA policy in allowing psychologists employed by the government to resolve conflicts between professional ethics and law by following the law and ignoring professional ethics. The Penn's policy remained in effect for a decade. In response to email evidence of close coordination between APA and the CIA and DOD by reporter James Risen in October 2014 in a book, APA leadership changed tack in November of 2014. They hired Chicago attorney and institutional corruption expert David Hoffman of the law firm Sidley Austin LLC to conduct an independent review of possible APA collusion with the CIA and/or DOD. Hoffman's team completed their report in early 2015, and as I and colleagues have summed up their conclusions, Hoffman and his team found intense collusion between DOD and APA officials to assure that APA policy did not constrain psychologists' involvement in military interrogations. They found evidence of systematic APA efforts to undermine post-Penn's APA critics and their attempts to expose and end psychologists' involvement in national security interrogations. They traced a nuanced public relations campaign that falsely presented an anti-torture facade and falsely asserted that the APA would investigate all credible ethical complaints of psychologists' involvement in abusive interrogations. In fact, Hoffman found that well-documented complaints were not actually investigated, but perfunctorily closed or indefinitely postponed, and then closed. The Hoffman report led to staff changes at the APA. The ethics director, who had been the lead spokesman for the association's interrogations policy, was fired. The CEO, deputy CEO, and communications directors left after receiving lucrative buyouts. However, a number of other staff members who had played roles in the association's interrogation policies remained. When the APA's Council of Representatives met the following month, in August 2015, they passed a ban on psychologists' direct involvement in national security interrogations and on military psychologists working in detention facilities operating outside of or in violation of the U.S. Constitution or international law, which was actually a policy passed overwhelmingly by the membership in APA through a referendum, but it had been undermined by APA interpretation of the policy. In 2015, this policy was strengthened by specifying certain UN authorities as the sources for determining whether a detention center was operating in violation of international law. As a consequence, in December 2015, General John Kelly, who we hear about in other capacities these days, ordered the removal of psychologists from all detainee relations at Guantanamo. Within weeks of the release of the Hoffman report, intense pushback began seeking to undermine its credibility and undo resultant APA reforms. The report was criticized as a prosecutorial brief rather than the work of a former inspector general and authority in institutional corruption. The methodology was critiqued as failing the standards expected of psychological research. And claims were made that by the time of the Penn's task force, DOD policies banned all forms of detainee abuse, thereby justifying the lack of any constraint on following DOD policy in the Penn's report. The APA board that authorized the Hoffman report and implemented the post-Hoffman policies was demonized. 5 of the principal actors in the Hoffman report, including 2 former APA staff members and 3 military psychologists, 2 of whom served as biscuits at Guantanamo, filed a defamation lawsuit against APA, Hoffman, and Hoffman's law firm. That lawsuit is still ongoing. Professional ethics complaints and threats of ethics complaints have been used in apparent efforts to silence those critical of prior APA policies. These efforts at Hoffman denialism are ongoing. In fact, they're escalating. There are disturbing signs that APA leadership is now more interested in protecting the association from further public exposure than helping the profession and the American public learn and incorporate the lessons from the past 15 years. At least 3 times in recent months, APA has published letters that reiterated pre-Hoffman positions of blaming reported abuses on a few bad apples and minimizing institutional and professional collusion and denial. Thus, the history of APA's response to having its collusion exposed is far from finished. Thank you.
Can you imagine if the Germans hadn't been thoroughly defeated? They'd be doing all this still. Trying to justify it.
Thank you very much. You very clearly outlined that not only did the APA endorse this stance on torture and cover it up and deny, but we have seen no such investigation into the other groups. And as a physician myself, it's very clear that physicians were heavily involved or must have been involved. And can we look to any kind of transparency there, or what else could we look to here now, not only with the physicians, but also nurses and every other type of medical professional who was either participated under orders willingly or unwillingly?
Let me just disagree slightly with the first summary.
Sure.
That I think most people in APA, a few people probably supported the policy in APA. Most people, it's more study of denial, of how people can avoid seeing what's in front of their eyes.
Yes, thank you.
I'm not saying that they were all torture supporters. Rather, they were interested in protecting the APA, and that blinded them to what was obvious to anyone else. On the question of what to do, we desperately need, I have a set of recommendations. This is the first one, and I've been pushing this for years. We desperately need a commission of inquiry for the health professions. Ideally, the professional associations would unite together to do this, but there's no sign if they're doing that. Whether we need to get a public record of how health professionals were involved in the same way that we're trying here to do for North Carolina's involvement, and to try and also have deeper thinking about lessons learned about how did this happen. How did professions dedicated to improving health and welfare close their eyes so massively to what was happening? Unfortunately, health professionals are like most other people. Most people close their eyes. And that's one of the lessons that we need to grapple with, is how do we change that? And the associations are more concerned about protecting the profession and protecting the associations than they are about protecting the public and ethics. And that's a major problem. I don't know how to change that. There's that old Jefferson quote about needing a revolution every 20 years, and things get ossified. And that's happened, I think, in all the associations. They sometimes, so for example, the nurses, there was a nurse who refused to participate in brutal force feedings. The Nurses Association did defend his right to refuse, but they did not say it's unethical to participate in brutal force feedings. They said basically every nurse can decide for themselves. Well, that's that's only half of the way there.
Essentially, you've outlined a catalogue of the most egregious ethical violations that we can either commit willingly or unwillingly as health professionals. And yes, as you say, medical professionals are people just like anyone else, but there is a higher standard that we are held to, and we can be struck off for the smallest thing, and yet there seems to be very, very little accountability or any punitive measures apart from the ethics director.
My colleagues and some in medicine filed ethics complaints with the AMA and with the APA and in various states against psychologists. I know there was a complaint against a physician in California. Not once did an investigation get opened by the APA or by any state licensing board. There were lawsuits with trying to sue the boards to force them to open an investigation, say it's your public duty. All those lawsuits were dismissed because of lack of standing, except possibly one case, but in any case, none of them even forced a licensing board to open an investigation. This is a major problem. So one of my second recommendations is that the health professional associations need to think deeply about how do you conduct investigations of matters that involve national security that are conducted in secret classified settings, and develop some best practices that they can help give to the states. Because I think one reason no one wants to take it on is this is huge. What state, you get volunteers on a state board. They don't know how to take on the federal government, the CIA, or the military. They need help. And so there might be a slightly better chance if they felt like there was backup and help with how to do it.
So we have received some very excellent audience questions. Unfortunately, in the interest of time and being respectful of our final witnesses' time, we are going to hold those questions. There will be an opportunity at the end of the hearing today to interact with Dr. Soldz and all of us and all the other witnesses as well. So please hold your questions. Please join me in thanking Dr. Soldz.